Chapter 20. The process of debate in the House of Commons by motion, question and decision. Introduction to process of debate in the House of Commons. A matter requiring the decision of the House of Commons is decided by means of a question put from the chair upon a motion made by a member. The essential stages in obtaining a decision of the House are the moving of a motion, the proposing of a question by the chair, and the putting of the question and collection of voices by the chair. At the conclusion of the speech, if any, made by the member moving a motion, the chair proposes the question, which repeats the terms of the motion, and debate may then take place. At the conclusion of debate, the chair puts the question, except when it has been withdrawn, and collects the voices, after which the chair announces that in their opinion, either the ayes or the noes are in the majority. If the opinion of the chair is challenged, the House proceeds to a division to determine which side has the majority of votes. Between the proposing and putting of a main motion, a subsidiary question on amendments may be moved, proposed, and decided in the same way. The moving, proposing, and putting of questions are often proceeded with formally, that is, without debate, or are required to be put at a specified time or point. Many questions before the House are decided in this way. The process of debate is described below under the following headings: motions, questions on motions, amendments to motions, requirements on chair to put the question, closure of debate, quorum of the House, decisions and divisions, status and recording of decisions, reversal of decisions. Motions. Substantive and subsidiary motions. A motion is a proposal made for the purpose of eliciting a decision of the House. Motions may either be self-contained substantive motions or one of several kinds of subsidiary motions. 1. Ancillary motions dependent on the order of the day, such as a motion that a bill be now read a second time, or, when there is a preceding motion that the report of a committee be now considered, that the House agrees with the report of a committee. 2. Motions made for the purpose of superseding questions, such as motions made for the adjournment of a debate. 3. Motions dependent on other motions, such as amendments. Rules regulating notices of motions. Manner of giving notice. Notice of a motion can be given, tabled, by being handed in either at the table of the House or, more usually, to the clerks in the table office. Notice of a motion can be published in a variety of ways. It may appear for the first time on the order paper for the day on which it is proposed to be taken, if this is the sitting day after the notice is given. It may, as is the normal practice with government motions, be placed on the list of remaining orders and notices printed in the future business B section of the order paper. And motions frequently reappear daily on the remaining order for long periods before they are placed on the effective order's notice. Notice may be given for a specific future day, in which case the motion is printed in the paper entitled Future Business A for the specified day. Finally, motions may be tabled by backbenchers for which no day has been fixed. These are known as early day motions or EDMs, and in most cases are not in practice expected to be debated. For more detailed rules relating to the adding and publishing of names added to these motions, see paragraph 2017. Members are required to declare relevant interest when tabling notices of motions and amendments, including cases in which they add names to notices of motions and to amendments tabled by others. A notice cannot be withdrawn from the notice paper of the day or the current issue of the future business paper in the course of a sitting, but by notice given to the table office, it can be withdrawn from a future issue. A member may not have the same notice standing in the future business paper for 2 different days. Period of notice. In general, substantive motions require notice before they can be moved, while subsidiary motions do not. Except where the length of notice required is laid down in standing orders, notice means at least one preceding sitting day. This means that relevant business for a day can be tabled right up to the close of business of the preceding sitting day. Notices of motions to which opposition seems unlikely to arise are frequently given during the day before the sitting on which the motions are to be submitted to the House, although the Speaker has deprecated the delaying of a motion so as to deprive members of an opportunity of learning the terms of a motion. A minimum of 5 and a maximum of 15 sitting days' notice is required under Standing Order number 23 for leave to bring in a bill, and under Standing Order number 90, at least 10 days' notice must be given of motions at the commencement of public business to refer a bill to a second reading committee. Under Standing Order number 121, 2 sitting days' notice must be given of a motion or an amendment relating to the nomination of members for service on select committees. For notice periods relating to amendments to bills, see Chapter 28. Under Standing Order number 22, notice of an amendment to a motion for which no day has been fixed, an early day motion, or of the addition of a name in support of such a motion or amendment, if given later than half an hour after the moment of interruption, is treated as if it were a notice handed in after the rising of the House on that day. Change of day for a motion. A member who wishes to change the day for which they have given notice must defer the notice to a more distant day, or, if an earlier day is sought, must withdraw the notice and give a fresh one. The new notice must conform to any requirements laid down in standing orders as to length of notice. The same notice of motion may not be given for 2 or more different days. Motions made without notice. Certain procedural motions relating to the transaction of business may be made without notice. These include motions made under Standing Order number 63, immediately after second reading, that a bill be committed to a committee of the whole House, a select committee, or a joint committee. Motions under Standing Order number 51 for giving provisional statutory effect to any proposal in pursuance of the Provisional Collection of Taxes Act 1968, and motions for the consideration of Lord's amendment forthwith. Motions arising out of a matter of privilege, including motions for an order of the House to the Speaker to make out the warrant for the issue of a writ for the election of a new member, are also moved without notice. A motion for a message to the Lords requesting the return of a bill which was incorrect due to irregularities in divisions has also been allowed to be moved without notice as a matter of privilege. A motion granting special powers to the chair of a standing public bill committee has similarly been moved without notice as a matter of privilege, following a report of disorder in the committee made in the House by the chair concerned. On the presentation of a petition seeking leave for a member or officer to attend a court as a witness, the motion for leave of the House has been granted has in the past been moved without notice unless objection was taken before the motion was moved. A motion to permit the Speaker to nominate no more than 3 deputy speakers to serve until the House has elected deputy speakers in accordance with Standing Order number 2A has been moved without notice. With the exceptions stated above, it is the almost invariable practice of the House that notice should be given of substantive motions. Waiver of the requirement of notice. The House can, in exceptional circumstances, waive the requirement of notice for a substantive motion if the motion is moved under the sanction of the Chair and with the concurrence of the House. Equally, the requirements for notice can be waived by means of a business of the House motion on a previous day. Motions have been made without notice to provide for a Saturday sitting, to alter the time for the next sitting of the House, or to regulate the adjournment of the House. When, under Standing Order number 13, notice was given on a Sunday for the House to meet on the following day at 6 p.m. to debate a substantive motion for its adjournment, an order paper was published in the usual way. Though by practice no notice could be given on a Sunday, it was considered that in such circumstances the standing order must override the customary requirement for a notice of a substantive motion. A motion to give immediate effect to a resolution of the House has also been moved without notice, for example after the House had rescinded and discharged the order for the appointment of a select committee. An order was made immediately for the reappointment of the committee with altered terms of reference. A motion to rescind the committal of a bill to a standing public bill committee has been made in a similar way. A message from the House of Lords communicating the desirability of appointing a joint committee has been considered without notice, and a resolution for concurring with the Lords agreed to. The objection of any member is enough to prevent the waiver of notice. Change of terms of notice of motion or of question. Modification of the terms of a notice of motion standing upon the notice paper is permitted if the amended notice does not exceed the scope of the original notice and the Speaker decides that it is proper for the motion to be moved in the altered form. If a motion is proposed which differs materially from the terms of the one on which notice has been given, it can be made only with the consent of the House or after a new notice has been given. On proposing the question, an opportunity may be taken to rectify any irregularities in a motion which has been moved without notice, or any irregularities which, although notice has been given, have previously been overlooked. Any such change is within the discretion of the Chair. The general rule that the question proposed and put from the Chair should repeat the terms of the motion on which it is based admits of certain recognised exceptions. Thus, on the stages of bills, the form of motion for the rejection of a bill that the House declines to give the bill a second or third reading, for various stated reasons, is translated by the Speaker in an amendment to the question that the bill be now read a second or a third time, expressed in the terms to leave out all the words after that and add the words embodying the reason for the rejection. Withdrawal of a notice. A member whose name stands first on the notice of a motion or an amendment to a motion may withdraw the motion or amendment even though other names have been added to it. A member who has added their name to a notice of motion may subsequently withdraw their name if the motion has not been moved or withdrawn. Rules governing the form and subject matter of motions. Matters which may be raised only on a substantive motion. As indicated in the following chapter, certain matters relating to the conduct of certain categories of persons or office holders, such as members of either House or of judges of the superior courts of the United Kingdom, cannot be debated except on a substantive motion which allows a distinct decision of the House. Critical language of a kind which would not be allowed in speeches in debate may therefore be permitted in motions of this form, but are not allowed in other forms, such as an amendment or the title of an adjournment motion. Matters awaiting judicial decisions, sub judice. The House has resolved that no matter awaiting adjudication by a court of law, including a coroner's court or a fatal accident inquiry, i.e. matters sub judice, should be brought before it. This covers both the content of members' speeches and the subject matter of motions and questions. The resolution means that matters currently before the courts cannot be raised in a motion or amendment save where legislation is under consideration. Though this does not include motions for leave to bring in bills. Where a ministerial decision is in question, where in the opinion of the Chair issues of national importance are concerned, or where the Chair otherwise exercises their discretion. The terms of the resolution and its interpretation are set out in more detail in Parrot 21:19. Matters already decided during the same session. A motion or an amendment which is the same in substance as a question which has been decided during a session may not be brought forward again during the same session. Since 1994, this rule has been applied so that in the case of 10-minute rule motions under Standing Order number 23, refusal by the House of leave to introduce a bill should be treated as the rejection of that bill at a substantive stage, with the effect that a bill with the same or a very similar long title could not be presented again in the same session. Attempts have been made to evade this rule by raising again, with verbal alterations, the essential provisions of motions which have been negatived. Whether the second motion is substantially the same as the first is finally a matter for the judgment of the Chair. The same rule has been applied to an amendment renewing a motion which had already been negatived. Some motions, however, have been framed with sufficient ingenuity to avoid this rule. On rare occasions, where the House has been offered a series of alternative proposals for its consideration, an order was made specifically directing the Chair to put the questions on later motions, notwithstanding any decision of the House on earlier motions. However, a question which has not been definitely decided may be raised again. Thus, a motion or amendment which has been withdrawn, or on which the Chair has declared the question not decided when it appeared that fewer than 40 members had taken part in a division, or for some other reason, may be repeated. In such cases, a member may speak again on the second occasion, where a certain course in relation to the procedure of the House has been rejected on a particular day, it may be revived on a subsequent day. The rule against anticipation. Formally, the House strictly observed a rule against anticipation, according to which a motion could not anticipate a matter already appointed for consideration by the House, whether a bill or an adjournment debate upon a motion. The rule survives in Standing Order number 28, which requires that in determining whether a discussion is out of order on the ground of anticipation, the Speaker must have regard to the probability of the matter anticipated being brought before the House within a reasonable time. Stated generally, the rule against anticipation, which applied to other proceedings as well as motions, was strictly enforced in earlier times, was that a matter must not be anticipated if contained in a more effective form of proceeding than the proceeding by which it was sought to be anticipated, but it might be anticipated if contained in an equally or less effective form. A bill or other order of the day is more effective than a motion, a substantive motion more effective than an unamendable motion expressed in general terms, or an motion for the adjournment of the House, or an amendment, and a general debate or motion for the adjournment is more effective than a supplementary question. In recent years, there have been several occasions when the rule has not been applied in particular instances. It remains the practice, however, that if a member declares their intention of raising a matter on the adjournment during question time, further supplementary questions are precluded, even where the member has not yet been allowed a specific opportunity for an adjournment debate. Length of motions. Motions for debate should not generally exceed 250 words in length. This rule has been interpreted to require that any amendment tabled, if added to the original motion, would not bring its total length above this limit. Some types of motion, for example those amending the House's standing orders or dealing with matters of technical complexity, may be considerably longer. Other rules relating to content of motions. The Speaker has directed that a notice of motion should not be printed because it was irregular or obviously not a proper subject for debate, being tendered in a spirit of mockery, or being designed merely to give annoyance. The Speaker has ruled that motions are inadmissible if they are multiplied with slight variations on the same point. The Speaker has also ruled against the excessive use of quotation in motions so as to prevent attempts to write statements or speeches made by persons outside the House into its record. On the same principles, the Speaker has directed that certain titles proposed to be given to their motions by members could be changed before the motions were printed. Manner of dealing with irregular notices of motions. A notice of motion which contains unbecoming expressions, infringes the House's rules, or is otherwise irregular, may, under the Speaker's authority, be corrected by the clerks in the table office. The alteration, if necessary, is submitted to the Speaker or to the member who gave the notice. A notice which is wholly out of order may be withheld from publication on the notice paper. If the member does not accept that decision, they should ask for the matter to be referred to the Speaker. If the Speaker decides to uphold the view of the clerks that the member is in, if the Speaker decides to uphold the view of the clerks, the member is informed, and if the member is still dissatisfied, he may seek to see the Speaker to argue the case further. If at the end of this process the member is still dissatisfied, they can raise the matter in the House, and if the member disagrees with the Speaker's ruling, they can challenge it by a motion. The object of this procedure is to save the time of the House. It is not the duty of the table office to inform a member who has given the notice of any irregularity that it may contain immediately it is given, but communication regarding an irregular notice is made to members as soon as the pressure of business permits. When a notice publicly given is obviously irregular or unbecoming, the Speaker has intervened and the notice has not been received in that form, if an objection is raised to a notice of motion upon the notice paper, it is for the Speaker to decide upon its irregularity, and if the objection is sustained, the notice must be amended or withdrawn. The House is also by order directed that a notice of motion be taken off the order paper.